So if you're a farming landlord and you're looking to get possession from one of your tenants, maybe you're thinking about selling your land, maybe you're thinking about going into a promotion agreement with a developer, or perhaps you're thinking of taking a lease for solar. These are all reasons why you might want to take back possession of your land. So often we'll have clients come to us and say, hey, don't worry, we've got an occupant, they've been farming for an awfully long time. Don't worry, there's nothing written down. The families are friends of ours. It's all good. The answer I'm afraid that I have to tend to give is that that could be quite tricky. But the first question I would ask you is this: when did your tenant start occupying? If they started occupying before the 1st of September 1995, then their tenancy will be governed by the Agricultural Holdings Act 1986. This does give your tenant quite a lot of rights, and we need to really pause for thought about what sort of notice we should be serving on your tenant so that we can be more sure that you will get possession back in order to do what you want with your land. If your tenant started occupying after the 1st of September 1995, their tenancy will be governed by the Agricultural Tenancies Act 1995. These tenancies have slightly fewer rights. They're far more commercial in their nature. So we might be serving a different type of notice depending, for example, on how frequently your tenant pays rent. I'll be asking you for a copy of your rent schedule so that you can show me how much they've been paying and when, so that we can determine how long a notice we need to give. Just returning to those 1986 Act tenancies for a moment, there are statutory notices that we can look at serving, but we're going to have to pause for thought on those. We're also going to have to talk about the possible risks of the tenant challenging those notices, because they can do a challenge in the tribunal against the validity of your notice. They're also really long notices. They are 12-month notices, and this can mean that your plans for your land could be slightly snookered depending on what notice we serve and whether the tenant challenges it. So I suppose in a nutshell, when you say to me, don't you worry, there's nothing written down, it'll be fine, I'll get the property back so that I can sell or enter into a promotion agreement for resi development, I'll be saying to you, let's just pause for thought a moment. Should we be thinking about negotiating an exit package with your tenant, a surrender deal, something like that, just so that we can buy some clarity for you in order that you can carry out the plans that you have for your land?